morning, Your Honors.
Good morning. Good morning.
Timothy Goodwin on behalf of the Law Office of Robert Eckert and Associates for the appellants John Steiner and Joan Steiner. May it please the Court?
Go right ahead. Did you wish to reserve any time? Since there won't be a rebuttal, I don't think so, but
I don't think it's going to be necessary.
I think the pressure is on you now since there's not an opposing side, right? So
Yes,
that places the pressure on you.
Yes, Your Honor.
Go right ahead.
This is a consolidated appeal of 4 cases originating out of the Probate Division of the Circuit Court for Pasco County.
Let me ask you a quick question. After the trial court's ruling, Judge Black authored Klatthaar, if that's going to...
Yes, Your Honor.
Is that going to be the dispositive case here?
Yes, Your Honor.
Just wondering.
So this appeal, it involves 2 guardianship and 2 incompetency proceedings filed against both, and separately, John Steiner and Joan Steiner. After being examined by an examining committee, the court held that neither Mr. Steiner nor Mrs. Steiner were incompetent. It dismissed those petitions, and it dismissed the action. I'll first speak about the lower court's error in ordering Mr. and Mrs. Steiner to pay the court-appointed attorney's fees when there was no finding of any lack of capacity. I'll then speak about the lower court's error in failing to make the proper factual findings in the attorney's fees orders that those fees were reasonable, necessary, and incurred on behalf of Mr. and Mrs. Steiner. As a remedy, I request that the order on objections to orders commanding payment of court-appointed attorney's fees and motion for reconsideration, which is in the appendix 36, which was entered on September 17, 2013, be vacated in whole, and that the order on motion to voluntarily dismiss pending petitions entered on September 17, 2013 as well be reversed in part to the extent that that dismissal is conditioned on the payment of court-appointed attorney's fees. This court has jurisdiction pursuant to Rule 9.170B, and I'll speak about Issue 1 first. The lower court committed reversible error when it ordered the fees to be paid for the court-appointed attorney's fees representing John Steiner and Joan Steiner to be paid by them when there was no finding of incapacity. In doing so, the court...
So never a guardian appointed, correct?
Correct, Your Honor. There was actually, with respect to John Steiner, there was never a finding of incapacity based on the examining committee.
Was it 2-1 vote on Mr. Steiner, was it, on the committee? One of them had 2 votes, if I recall correctly, at least at one stage.
I believe that was correct, but there was never a finding of incapacity based on the examining committee reports.
As Judge Black points out, there's a gap in the statutes?
Yes, Your Honor, there is this gap. There's this gap that exists when there is no finding of incapacity and a court-appointed attorney is representing the alleged incompetent. When there's no such finding of incapacity, there's simply, the statute doesn't permit attorney's fees to be paid.
So if we agree with you, the simplest reversal to write is there's a precedent that says in the absence of the appointment of a guardian, there's a gap in the statutes for which no fees can be authorized by the trial court to reimburse these people, and we're pretty much done, wouldn't you say?
Yes, Your Honor. And that's the remedy we're asking for. And not only do we ask that this honorable court reverse that order directing the order of payment of fees, but that order of dismissal was also conditioned on the payment of fees. So we're asking that conditional order be granted, or that it be vacated in that limited way, and this action is actually dismissed.
I'm curious about the gap in the statute. Was the examining committee paid?
I don't. The examining committee I believe, is paid by the state, and then if there is a finding of incapacity, statute 744-1082 permits that examining committee be reimbursed by the estate of the incompetent. So I don't know whether the examining committee was actually paid, but the procedure is that the examining committee would be paid by the state initially.
And as to the attorney's fees, was there a stay issued, or were the attorney's fees paid by the Steiners?
The fees were not paid.
Well, it sounds like there's a gap that needs to be fixed by somebody, because otherwise you have these attorneys who are being court-ordered to do a task, and then if incapacity is not found, then they're being forced to do the work pro bono.
Yes, Your Honor, and that is a gap that this court has recognized in Klatthaar. earlier in this year. And it's a gap that exists. These court-appointed attorneys are aware of the gap, and unfortunately, the legislature has, whether intentionally or not, created this gap, and I guess it can be seen as a business risk, that if you volunteer to be appointed as a guardian, you undertake the business risk that if there is a finding of incapacity, you can be paid either from the state of Florida or from the estate of the alleged incompetent, or if there's no finding of incapacity, you will not be paid.
Unless you can establish the petitioner acted in bad faith, right?
Yes, Your Honor, and there's been no finding of bad faith in this case.
Right.
If there's no more questions on this first issue, I'm prepared to move on to the... Okay. The next issue I want to address is issue 3 in the brief, and that is that the lower court committed reversible error when it failed to make express findings that services performed by the court-appointed attorneys benefited their respective client, and that also there are no factual findings supporting the court's determination that the fees were reasonable. Attorney's fees are charged to the estate of the ward must benefit the estate of the ward. That's provided for in 744.1081 and also in this court's ruling in a case from 2012 in Ansley, which is cited in the brief as 94 Southern 3rd 711. In that case, the court has interpreted 744.108 to require that an attorney's entitlement to payment is subject to that limitation that his or her services must benefit the ward or the ward's estate. In each of the fee orders, the REIBER fee order, the Snively fee order, and the KOUSKOUTIS fee order, there is no such finding that any of the services benefited the estate of the alleged ward. For that reason alone, those fee orders and any order based upon those fee orders or awarding fees.
In fact, isn't there some evidence that some of the fees were incurred in opposing private counsel's motion to be substituted?
Yes, Your Honor. I believe you're referring to those fees that were billed by Attorney Snively. Attorney Snively was initially appointed as a court-appointed attorney for, I believe it was John Steiner, Mr. Steiner, and Mr. Steiner, within a month or two, hired private counsel. Now, much of the fees that were billed by Attorney Snively were incurred in challenging Mr. Steiner's private counsel's motion to substitute counsel. Clearly, that doesn't benefit the ward or the alleged incompetent. It only benefits Mr. Snively. And since there is no finding that these fees benefited the estate, and so therefore those findings are not only non-existent, but those orders are not entitled to any discretion because there are no factual findings. We then go to the orders, look at them, and realize that the fees that were billed, there's some serious problems with them, and they simply contradict the court's findings as to reasonableness and necessity. I can make myself available for any questions on this issue, but simply the fee orders do not contain the necessary factual findings, and therefore they must be vacated. If there's no further questions, thank you, Your Honors.
Thank you.